Sir, you were charged, do you speak English?
Yeah.
Yeah, no,
Yes. John.
better. You're charged with reckless driving, up to 30 days in jail and or a $500 fine. Hey, Conrad, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Your Honor. What's the last name of this?
Turu Biartes, Turru.
Thank you, Your Honor.
Sure.
Okay. The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop. The undercover officers also identified the driver as a slim Hispanic male with curly hair. The officers observed the defendant in the driver's seat, and the defendant admitted to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go.
Okay, pause. This guy is literally doing donuts just feet away from other cars and admits it. Street takeovers aren't just reckless. They're a fast track to a criminal record. Is this just boys being boys, or a serious threat to public safety? Drop your thoughts in the comments.
Or with the case, have you seen if he has a valid license?
I'll run it, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bombs. Do you understand, sir?
Yes, Your Honor. I apologize. It's loading right now.
Yes, no problem.
It's eligible, Your Honor.
Okay. You mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your Honor.
Okay, ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27th, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant, and the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Now hold up. That's the second defendant today. Hit with no contact and no weapons orders. These conditions are strict for a reason. They're not just a slap on the wrist. They're meant to prevent things from getting worse. Do you think these orders actually work? Or are they just legal formalities?
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, man. We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a reset. Victoria will give you 30 days, but I'm going to have you also take a seat in the jury box. So we'll get your bond conditions. We'll have you sign it, and then you'll be free to go, man. All right? Please. Mr. Ware, you're charged with unlawful carrying of a weapon. You're facing up to a year of jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 28th, 2024, the officer was dispatched to a robbery that just occurred in Harris County, Texas at a restaurant. While en route, the officer observed males walking on the south side of the store where the robbery had occurred, matching the description the reportee provided. The officer called in an attempt to contact the two individuals and located the two males wearing dark hoodies, dark pants, and shirts tied to their heads that looked like makeshift ski masks. The officer made contact and asked if it was okay if they were patted down for weapons, and both individuals ran off. A short pursuit lasted approximately 50 feet, where the co-defendant slipped on a puddle of water, and the defendant ran approximately 5 feet before being grabbed by the officer. The defendant, 19 years old, whilst trying to stand the defendant on his feet to walk into the patrol vehicle, the officer found on the defendant a loaded Glock 9mm, which fell out of the pant leg of the defendant.
So this is part of an ag rob as well, right?
Amanda Marsh.
Yes,
What happened on the ag rob?
One moment, Your Honor. So during the ag rob, the complainant stated that while he was walking into the store to grab his food order, the two males stood outside the store watching him, and as he walked out of the restaurant, they blocked his path, and one of them pulled out a gun on him, and the other yelled at him for his wallet and keys.
Where is this?
It was, one moment, there's an address, but not a name of the business. At a Sonny's food store.
Got it. Mr. Ware, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. I'm now also giving you a curfew. I don't want you out in the middle of the night. And I'm going to put a monitor on your ankles so I know where you are at all times. Do you understand? If I find that you're a danger to my community, I'm going to lock you up and I'm going to make your bond so high. Do you understand, sir? No contact with the co-defendant in this case and no weapons as well.
Yes, sir.
How old are you, sir?
19.
Did you graduate from high school?
Yes, sir.
What are you doing with yourself now?
Not much.
Are you working?
No, sir. I was planning on going to the military. I was talking to a military.
I want to know what you're doing with yourself. If you're working, if you're doing anything, because I want you to get a job. Too much time on your hands, you become self-destructive. You need something to do.
Forklift license. I know we're going to a class for forklifting.
Good. Get it done. You need to get a job. And I want to make sure that
That part right there, Judge Fleischer keeping it brutally real. Life sucks without money. Not your typical courtroom advice. But he's not wrong. This is where legal consequences meet real-life coaching. What would you do if a judge gave you 2 weeks to prove you're turning things around?
you're going to get a job. I'm going to provide you a lawyer today, but I want to see here within the next couple of weeks what you have done to get a job. If you've done nothing, life's not going to go well. Do you understand?
Sir.
In this life, you have to be productive. You have to either get yourself an education or get yourself a trade, a job, because I'm going to tell you now, when you turn 40, if you don't have a career, if you don't have an education, if you don't have anything, this life is not going to be a good one for you, because I'm going to tell you, life sucks without money. You need money, otherwise it's going to be just a rotten toilet of an existence. Do you understand?
Yes, sir.
So we're going to make sure here you're going to leave better than you came. So you must either get a job or get into school full time. Do you understand?
Yes, sir.
I'm going to give you a lawyer today, and I'm going to bring you back in 2 weeks, and we'll see what you've done with yourself.
Yes, sir.
All right. Odd McLean.
Yes, sir.
Mr. McLean, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The officer was dispatched to an apartment in Harris County, Texas, in response to a disturbance. Prior to their arrival, the officers were told the defendant was in an altercation with the child's mother, was intoxicated, and had a firearm. Upon arrival, the officers observed the defendant banging on the door to his residence, and the officer told the defendant to show his hands, and the defendant ignored them. The defendant then pulled his handgun from his waist to show the officers that he had it, and then placed it back into his waistband approximately 4 times. The defendant eventually put the handgun down, but told officers they would have to tase him to get him to stop. The officers then attempted to detain the defendant, but the defendant continuously pulled his hands away and kept placing them in his pockets. The defendant was then tased twice, but kept putting his hands back into his pockets. The officers were eventually able to detain the defendant.
Did you say, initially you said he was intoxicated, right? Is that what you
Yes, he was
said?
reported intoxicated.
Okay. Mr. McLean, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs and not to be in possession of weapons. Do you understand? What do you do for a living, sir?
Photographer. Do photography.
Okay. What kind of income do you have from photography?
Income coming in. What you want to know, monthly?
Yeah. and Do you have the ability to hire a lawyer?
Yes.
Okay, we'll give you time. So I'm going to have you meet with Victoria. We'll have you sign a reset. I'll have you get with Fleischer for your bond conditions. After that, you're free to go. All right? Please. Okay. Ready? Yeah, sorry to keep you waiting.
How are you?
Do we have Zuberi, right?
How are you?
Good, good, man. We have a,
We've been working hard. The case was filed late April. We had a retained lawyer in the beginning. He came to me middle of June. I subbed in late June. I had a couple settings.
where do you want to go? What do you want?
We're asking for about 30 days to flush some stuff out. And I think ultimately what I'm slightly disappointed with is the way the case was presented by the agency to the DA's office. It's not their fault. We've been put in a time crunch where we got to November and we began to run up against your 180 days. And I think we all kind of realized the agency didn't bring over what they needed to bring over. So
Are you still lacking stuff?
I think we're all in a position where it's less, some of the initial discovery is complete, but because we're all working so hard, there's some subsequent discovery that needs to be done based on some things that we. And so Kelsey's been great. She's working hard, talking to people.
But I mean, what do I need to do? Because we're now at 240 days. We're still missing stuff that's unacceptable.
I would suggest this is one of those moments where I would say we've all been doing this a long time. If you just trust me, and I say we really just need 30 days to work on some things and then come back, and I think we'll be in a better position then to know with clarity whether we're working this out or whether we're not, and we need a trial date.
Well, then I'll give it to you, Lon, but at the next setting, it's clear trial, you know? Like, that's it.
And I appreciate your position is like, hey, look, I've got and have an idea of when and how I want to move things. Every now and then things get messy. This one's gotten a little messy, but
Typically, when we face this type of dilemma, what I do is I order them and I subpoena the people who have,
yeah, this is a little different than that. This is different. And if we were in one, and I think you did that back in November because there were some screenshots or something that maybe weren't complete yet. And then so you asked for a compliance hearing and then some more information was provided, which again, really only happened because the agency in the beginning didn't have a detective assigned to the case to really work it up and bring it over. Like I'm used to small town, like detective work. This didn't happen here. And so a lot of it's been thrust in their lap, unfairly probably. And so she's good, we're all good. Got good
Right,
lawyers,
so-
good lawyers working on it. If you give us 30 days,
I'll give you the 30 days, but at the next setting, it's clear trial. I mean, it's it, because by then we'll be, you know, what, 275? So we're close to.
Track 60 that I wasn't on it.
Yeah, I mean, and that's why I'm giving you the benefit of the doubt.
3 for 1.
Okay, all right, we got it.
Thank you, sir.
Okay.